Chief Justice, Justice Kiefel of the High Court, judges and retired judges of the Supreme Court and other courts, members of the profession, distinguished guests, ladies and gentlemen. I welcome all of you here, including those of you who are virtually present, whilst at the Townsville, Mackay and Cairns courthouses. Welcome to the first of the lectures in the series of 6 lectures which are organised by the Selden Society and the Supreme Court Library. This evening we are to be treated to a lecture about Sir Harry Gibbs by a former associate of his, David Jackson. David Jackson was Sir Harry's associate whilst Sir Harry was a judge of the Supreme Court of Queensland. And therefore we know that David will be able to offer a special perspective on his life and work. I brought with me the précis of David's CV, but if I were to read it out, there would be no time left for the lecture. So if I can just mention briefly that David Jackson AM QC, as he now is, graduated from the University of Queensland with a Bachelor of Arts as long ago as 1963 and a Bachelor of Laws the following year. As I mentioned, he worked as an associate to the Honourable Sir Harry Gibbs, who was then a judge of this court here. He was called to the bar in 1964, appointed Queen's Counsel shortly thereafter in 1976, and worked in private practice at the bar in Brisbane until 1985 before becoming a judge of the Federal Court of Australia, stationed in Sydney. He now leads new chambers in New South Wales, and his principal areas of practice are described as appellate, constitutional law, arbitration and mediation. David Jackson is a distinguished orator and writer, and obviously a very distinguished silk at the private bar. Could you please welcome David?
Thank you very much, Justice Fraser, Chief Justice, Justice Kiefel, distinguished guests, and ladies and gentlemen. May I thank the Selden Society for inviting me to deliver this paper in relation to Sir Harry Gibbs. I had the privilege, as you've heard, to be his associate in 1963 and 1964 when he was a judge of the Supreme Court of Queensland. I appeared before him after that on a number of occasions when he was a judge of this court, and on many occasions I appeared before him or before courts of which he was a member in the High Court, sometimes in cases which were acutely political. After his retirement, we both lived in Sydney, we kept in contact, and I was pleased that he asked for me to visit him in hospital a few days before he died in 2005. He was a very sick man when I saw him. We both knew he was dying, and we uttered the trivialities and banalities so common on such occasions. May I mention first where some other material concerning him is to be found. There are many such pieces, some fragmentary, some fuller. The fullest is a biography of Sir Harry by Joan Priest, as has been mentioned, Without Fear or Favour. It was published in 1995, sponsored by the University of Queensland Law Graduates Association, and it also contains an appendix by Peter Connolly, a former judge of the Supreme Court of Queensland, dealing with Sir Harry's time on the High Court and thereafter. In 2003, the Supreme Court of Queensland Library published a volume, Queensland Judges on the High Court, edited by Michael White QC and Adam Ramtula. It contained the proceedings of a conference on the theme Queensland Contribution to the High Court. The Honourable Justice Glenn Williams, then of the Court of Appeal, presented the paper on Gibbs. I presented the commentary. As I said to Glenn Williams a little while ago, I would, for the purposes of this, as I said I would, for the purposes of this paper, I have plagiarised shamelessly his paper as required, and also repeat some parts of my commentary. You'll also find material in the Oxford Companion to the High Court of Australia 2001 in the entries Gibbs, Harry Talbot, which Joan Priest and I contributed, and Gibbs Court by Professor Anne Toomey, and some of what I'll say repeats comments which I wrote in the obituary in 2005 in the Australian Law Journal. May I also, at this point, like to thank our daughter Louise Jackson of the New South Wales Bar for her assistance with the PowerPoint, which is quite beyond me. Harry Talbot Gibbs was the son of Harry Victor Gibbs, a prominent solicitor in Ipswich for more than 50 years, and of Flora MacDonald Talbot Woods. May I say two things about names? First, to the family, the A in Talbot is long, Talbot, and secondly, Sir Harry Gibbs, from a very young age, was known to his friends as Bill. Despite the fact that his father was then in practice as a solicitor in Ipswich, Bill Gibbs was born in Sydney. He was born on the 7th of February 1917 at 99 Gordon Street in Paddington, and the birth certificate records the witnesses to the birth as being Dr. Windeyer and Sister Cook. I checked on the lineage of Dr. Windeyer with Bill Windeyer, a retired Supreme Court judge in New South Wales, and the son of Sir Victor Windeyer, who'd been on the High Court, and he confirmed that there was a family relationship, not too surprisingly, with a name like Windeyer. And it's an interesting historical vignette that one member of the High Court's been delivered by a relative of another. But of course, Australia was a much smaller place in 1917. Although he'd been born in Sydney, Bill Gibbs was brought up in Ipswich. Children, as you know, do tend to grow up and up and up and up. He attended Ipswich Grammar School and then the University of Queensland. In the photograph, you will see him in the back row, sixth from the right, and also at that time at Ipswich Grammar was Douglas Campbell, D.M. Campbell, as he was generally known, to distinguih him from Walter Campbell, W.B. Campbell. D.M. became a Supreme Court judge. His son is Douglas Campbell, a silk at the Queensland Bar. D.M. and Bill Gibbs later took silk at the same time as the newspaper of the 8th of February 1957 records. As I said, he attended the University of Queensland. He was inaugural president of the Law Student Society and vice president of his college, Emmanuel. And in the Emmanuel College photograph, he's seventh from the right in the second row. He also was elected president of the Students' Union. The other candidate was R.S. Hopkins. Now, R.S. Hopkins didn't win, but Dick Hopkins became a distinguished engineer. He frequently gave expert evidence, and he was a relative, or relative by marriage, I'm not quite sure which, of the Hanger family. Now, Sir Harry Gibbs graduated in arts in 1917 with first-class honours, and in 1939 in law, again with first-class honours. Life at Queensland University, however, was not all unmitigated work and merit. He was a participant in the rather shabby episode reported in that Journal of Record, Semper Floreat, of the 30th of September 1937 under the heading Women's Club Ravaged. The basis for the intrusion into the Women's Club appeared to be the fact that the words defining qualifications for membership of the Women's Club did not specify that members had to be women. His legal learning, no doubt influenced by that experience, He said in his judgment in the High Court in Wacale Developments and Realty Developments in 1978, some 41 years later, that when a term is defined, it's given a special meaning which must be applied whether or not it accords with the ordinary meaning. These days, of course, the incursion to the Women's Club would probably be entirely unnecessary. Reliance could simply be placed on the Sex Discrimination Act. But I suspect he wouldn't have found that quite as attractive. There was also the occasion in July 1938 when the Brisbane Telegraph carried the headline, "Students Stranded in Bay." It was said that the engine of their vessel had failed and that the students had had to spend a cold night together at Bishop Island near the mouth of the Brisbane River. The students, as is apparent from the photograph, appear to have survived the ordeal in remarkably good spirits. And it may be noted that the engine of the vessel restarted, apparently without trouble, on the arrival of a water police launch. Sir Harry and Tom Matthews were the first graduates of that university's law school to graduate with first-class honours. They were thus entitled to admission to the Queensland Bar in 1939 without payment of fees, although they had to establish that entitlement before the full court. The report of those proceedings can be seen in In re Matthews and In re Gibbs in 1939 Queensland Weekly Notes. Their admission to the bar was on the 30th of May 1939, but the initial period of practice could only be brief. World War II was but months away. He was an early enlistee on the 2nd of December 1939 and remained in military service for the 6 years of the war, being discharged in December 1945. On his initial enlistment, he was given the rank of Staff Sergeant. When I was young, I spent 12 years in the part-time army, the Citizens Military Force, as the Army Reserve was then known, and encountered a number of Staff Sergeants, and it is difficult to think of anyone to whom that rank was less appropriate. Staff Sergeants tended to be, or the term Staff Sergeant tended to be a synonym for lurk merchant. Fortunately, the Army took the same view and he was commissioned 6 months later. He served in Australia and in New Guinea. He received promotions to Major and was mentioned in dispatches. After completing his military service in December 1945, he resumed practice at the Queensland Bar. May I devote a moment to an event in his military service? It concerns the Battle of Brisbane. Riots and fighting in November 1942 between Australian and United States troops outside the American PX, then on the corner of Adelaide and Creek Streets. Much was censored about it at the time. Much has been written about it since. What I'm about to say comes from Peter Thompson and Robert Macklin's 2000 work, The Battle of Brisbane. The authors note that there was a brief lull in the rioting as the wounded Australians were carried away, and that the lull gave a Major Cummins, Assistant Adjutant General of the Queensland Line of Communications area, an opportunity to take command outside the PX. Cummins summoned a group of helmeted Australian Army pickets to disperse the mob. They were armed with .303 rifles, but the rifles weren't loaded. The authors go on. The use of a shotgun by the Americans on Australian troops had enraged the rioters, and they urged the pickets to join them. One policeman said that a majority of the pickets, who'd been hastily drawn from signals personnel, had doubled back, mingled with the rabble, passed their rifles over to anyone who'd take them, and changed their helmets for hats or went bareheaded, after secreting their steel helmets. He heard rioters urge the pickets, "Shoot the bastards, or give us your guns and we'll use them." Now, there was, of course, an Army Court of Inquiry after the event. The fact that a policeman's recollection of events might differ from that of others was brought home early to Sir Harry. The book continues. At the subsequent Army Court of Inquiry, Captain L.W. Barnes, the senior Australian provo, meaning military policeman, present when the fighting broke out, explained that he had ordered 5 or 6 MPs to remove their armbands and move into the crowd to see if they could influence them to keep quiet. Even though Captain H.T. Gibbs, the Queensland Area Deputy Assistant Adjutant General, claimed to have seen possibly 20 MPs thus undressed. Now, I'm sure that Captain Gibbs gave his evidence to the Court of Inquiry in what the old judges used to call a frank and manly fashion. I suspect, however, that Captain Barnes' account was preferred. Then, in 1945, the war was over, and so back to the bar, but not this time as a 22-year-old, but rather 6 years older and as a man with responsibilities. The responsibilities came about because on the 17th of November 1944, at the Presbyterian Church in Ann Street, he and Muriel Dunn were married. He was 27, she 25. Muriel was herself a lawyer. She came from Maryborough from the well-known Dunn newspaper family. It was a marriage of two immensely compatible people. They were, to use an Australianism, mates, close mates, and remained so throughout their joint lives. I said earlier that children and families grow. As you can see, they keep on growing. There were 4 children of the marriage. Barbara, a film producer, Margaret, a psychologist and co-founder of the polling company, ANOP, Mary, a teacher librarian, and Harry, who is Deputy Director of General Medicine at the Alfred Hospital in Melbourne and an Associate Professor of Medicine at Monash University. Margaret and Mary are researching the Gibbs family history. Some of the photographs tonight come from their collection, and I thank them for their assistance. I should mention one final thing about the war before turning to his practice at the bar in the post-war period. In 1944, he'd assisted in planning unified post-war government for the then territories of Papua New Guinea. No doubt this played a part in his obtaining in 1946 the degree of Master of Laws from the University of Queensland, the thesis being the laws of the territory of New Guinea, their constitutional and basic content. He practiced at the Queensland Bar until 1961, taking silk on the 7th of February 1957. His practice developed rapidly and he acquired a considerable reputation extending beyond Queensland, particularly in appellate, constitutional and opinion work. He appeared in the High Court on quite a number of occasions. This is, I think, a wonderful photograph capturing the extent to which he enjoyed life at the bar. But it captures also the essence of the bar. Around you is the law as it has developed so far, statutes, law reports, textbooks, articles. But in front of you lie the problems of the day. And the day is different from the day on which the decisions of the past were given. Some of what lies behind those decisions is enduring, some not. And 80 years ago, many of the decisions relied on were cases where the court in question had arrived at the right, in inverted commas, result in a particular case, but without a very clear identification of the legal principle underlying the result. One of Sir Harry Gibbs' great skills, both as counsel and jurist, was to identify principle behind instance, and this was so whether it be in matters of legal practice and as to matters of substantive law. He enjoyed his life at the bar, but the bench beckoned, and he was appointed to the Supreme Court from the 8th of June 1961 at the age of 44. You'll see the newspaper report of it, followed by a photograph. He looks very young. He can be seen in the Supreme Court's ceremonial robes, including the full-bottomed wig in the next photograph. Whitehouse and Queensland, in the Privy Council, in which he defended successfully the validity of the state's liquor licensing fees, was his last case as counsel. He knew he was being appointed to the Supreme Court shortly afterwards. He was the first of those who had been undergraduates at the University of Queensland Law School to be appointed to the Supreme Court, and the Solicitor General at his swearing-in said that his appointment had been greeted with unanimous assent. He's been one of the most outstanding counsel, and in particular, one of the most eminent lawyers of his generation. At the time when he was appointed to the Supreme Court, he'd also been a part-time lecturer at Queensland University in commercial law, evidence and legal interpretation, and had been a member of the board of the faculty of law of that university from 1954, and he'd been a member of the barristers' board from 1951. The structure of the courts was then quite different. There was no Court of Appeal in Queensland, there was no Court of Appeal in any of the states, and the judges sat on the full court or Court of Criminal Appeal in fairly strict rotation. The family court and federal court had not been established. The Supreme Courts were invested with and exercised almost all federal jurisdiction. In a day, the judge appointed to deal with short or urgent matters, the chamber judge as they're called, might deal with a number of undefended divorces, make a number of people bankrupt or release them or discharge them from bankruptcy, wind up or reconstruct companies, dispose of disputes as to custody or access to children, construe wills or contracts, deal with applications for injunctions, resolve interlocutory disputes in pending litigation, and then finish off the day with perhaps an application for bail. What was noticeable was his facility in each area, whether presiding over a criminal trial or in the Court of Appeal or in the full court or on circuit or hearing civil litigation or as the chamber judge. His ability to master the law and the facts rapidly was obvious. So too with procedural matters and with rulings on evidence. His fairness was manifest and his broad experience stood him in good stead for his later appointment to the High Court. There was a collateral benefit from the presence on the bench of a young, very able and very articulate judge. Some of the other judges, perhaps a touch weary, perhaps a touch shop-worn, found the competitive urge rekindled and their work improved. Not all the judges of those days, I have to say, were workaholics. And one or two found it good to have a very hard-working young judge to whose broad shoulders some of their own work might be moved. As you've heard, I became Sir Harry's associate in early 1963. I was the third to hold that office. The first was a retired naval officer, Captain Rhodes, always known as Dusty Rhodes. Dusty was a distinguished-looking man of some bearing, as can be seen from this photograph, which was taken in 1950 when he was official secretary to the governor, who was then, I think, Lieutenant General Sir John Laverack. It was taken at the dedication of the memorial gates at the Marist College, Ashgrove. Dusty was there as Gibbs' associate for the remainder of 1961, no doubt to show the new and much younger judge the ropes. Quite a few old soldiers served as associates in those days. He was then succeeded in 1962 by Glenn Williams, who's here tonight, later himself a leading silk judge and member of the Queensland Court of Appeal, and I followed in 1963 and 1964. I hope that I don't in any way offend Glenn by saying that I do not think that either he or I could match the strong jaw, firm gaze and understated elegance of the old sea dog. Judges' associates, of course, are young and impressionable and tend to regard the judges to whom they are associates through rose-tinted spec glasses. But to this impressionable young man, it seemed clear that he was a judge of outstanding ability. That's a long time ago. Since then, I've seen many judges in many courts in this country and in others. My youthful view hasn't changed. It's been reinforced, and I know that Glenn Williams holds a similar view. While a judge of the Supreme Court, Sir Harry was appointed to conduct 2 inquiries. The first in 1963 was as chairman of the inquiry into the Australian sugar industry. The second in October 1963 to April 1964 was as Royal Commissioner inquiring into the enforcement of laws in relation to the National Hotel in Brisbane. The former inquiry recommended expansion of the sugar industry, a recommendation which was well received at the time. The conduct of the National Hotel inquiry, however, was later criticised as too legalistic and not sufficiently investigative. The issue is discussed in Joan Priest's book at some length, pages 43 to 51 for those interested. Could I indicate a photograph of the inquiry leaving the National Hotel after an inspection of it? On the right is Mr Justice Gibbs. To his left, Lindsay Bath, Counsel Assisting and later Chief Judge of the District Court. Doug McGill QC, Counsel for the National Hotel, is next. Doug McGill was a good friend of Gibbs. He was sadly killed in a motor accident not so long after these events. His son John was a member of the District Court. Bringing up the rear is Walter Campbell, WB, QC, later Judge, Chief Justice of Queensland and Governor, his son Wallace, is at the bar. You will see that there is one person there who is not taking account of the possibility of skin cancer, and that is me. I'd been appointed Secretary to the Commission, but I am somewhat disloyally inclined to agree with the criticism of it. Having conducted a number of both private and public inquiries since then, I think the lack of results reflected the times, the somewhat inadequate resources of the inquiry, and a significant imbalance in legal representation. Notwithstanding the dramas of the National Hotel inquiry, for the several years following it, Gibbs consolidated his position as a judge of the Supreme Court and by general agreement was the outstanding judge. But 1967 brought about a dramatic change in his life and in the life of his family. He was appointed a judge of the Federal Court of Bankruptcy and a judge of the Supreme Court of the Australian Capital Territory, and he and his family moved to Sydney. This is a photograph after his swearing in the Australian Capital Territory. To adopt this course seemed surprising, I have to say. The office of Federal Judge in Bankruptcy seemed hardly the most glittering of prizes. And much of the work of the Australian Capital Territory Supreme Court was of a district court level because there was no district court. My view is that there were 2 factors of particular significance in the decision. One was the carrot from the Commonwealth. It was proposing a new federal court, the Commonwealth Superior Court, and it would need a young, active, vital Chief Justice. For a short interim period, say 6 months, the intended Chief Justice would be the Federal Judge in Bankruptcy to replace the deceased Mr Justice Klein with the jurisdiction in bankruptcy, then to go to the new court. Now, a proposal of such a nature was likely, I think, to have fallen on fertile ground with Sir Harry, because of what I suspect was the other factor, namely the appointment in the previous year of Mr Justice Mack as Chief Justice of Queensland to replace Sir Alan Mansfield. I'm not suggesting personal animosity, I don't think there was on either side, but the appointment was generally seen as a step backward. It seemed to indicate that not much stock was to be placed on ability or on the generally accepted views as to appropriate judicial temperament or on diligence. However, the proposal for a Commonwealth Supreme Court, Superior Court, died a political death, and so for a time, limbo, if not purgatory. But salvation emerged in a relatively short time. He was appointed to the High Court in 1970. The appointment was not entirely unexpected. It was to succeed Sir Frank Kitto, who resigned to become Chancellor of New England University. It was said that there had been some tension between Kitto and Sir Garfield Barwick, who'd become Chief Justice in 1964. Whether this was right or wrong, I'm not able to say, but I do know that on the occasions when I saw Sir Frank on the bench, his temper matched his stature, which was short. The High Court became a calmer place with Sir Harry's appointment. At his swearing-in, Tom Hughes, the Commonwealth Attorney-General, paid tribute to his distinguished and broadly based practice, to his wide-ranging judicial experience, and to the fact that his appointment had been received with acclaim. You will see the High Court of that time. From left to right, Justice Walsh, Justice Windeyer, Sir Edward McTiernan, young Sir Edward, Chief Justice Barwick, Justice Menzies, Justice Owen, and Justice Gibbs. A pretty grim-looking lot, I think you'd have to say. For those who are not familiar with these things, it reflects the relative seniority of the members of the court. Chief Justice in the middle, the next most senior on his right, number 3 on his left, and so on. The most recent appointees, Walsh and Gibbs, were on the wings. Another record of the occasion can be seen in this picture. The swearing-in took place at Darlinghurst in Sydney. The High Court had not yet moved to its permanent home beside Lake Burley Griffin. As was the custom in those days, a knighthood followed. The Governor-General, wielding the sword, is Sir Paul Hasluck. Sir Harry Gibbs' 17 years on the High Court saw great changes in its membership, in its role, and in the nature of its work. In relation to its membership, retirements of Sir Victor Windeyer in 1972, Sir Edward McTiernan in 1976, and deaths, Sir William Owen in 1972, and Sir Cyril Walsh in 1973, and Sir Douglas Menzies in 1974, meant that in just over 6 years he'd become the most senior member of the High Court other than Chief Justice Barwick. Sir Kenneth Jacobs, who'd been a later appointment, also resigned in that period, and after Sir Harry became Chief Justice, there were 2 further deaths of Aiken in 1982 and Murphy in 1986, and Sir Ninian Stephen resigned to become Governor-General. The High Court in 1976, at this time you can see, and it is taken in Melbourne at the High Court's then Melbourne premises in Little Bourke Street. The High Court at that stage was still peripatetic. It followed the sun and came to Queensland for about 3 weeks each June. While there was a good deal of work, there was still some time for relaxation and for casual attire. Next, on Sir Harry's left is Sir Anthony Mason, slightly less formally dressed, and I think the man in the dark shirt, second from the right in the front row, is Jack Kimmins, whose son who went on the District Court and whose son is at the Queensland Bar. Now, while the process of abolition of Australian appeals to the Privy Council had commenced in 1968, it wasn't completed until the passage of the Australia Acts in 1986. At the time of his appointment to the High Court, a significant range of Australian matters could thus still be heard by the Privy Council, including some appeals from the High Court itself. It had become the custom to appoint members of the High Court to the Privy Council as members of the Privy Council, and he was appointed a Privy Councillor in 1972. He was, as I understand it, the second last High Court Justice so appointed, Sir Ninian Stephen being the last. He went to London on 3 occasions to sit on the Judicial Committee of the Privy Council. Its then premises were on the corner of Downing Street and Whitehall, 2 doors away from number 10. He told me that the room for the visiting judge from overseas had a plate on the door saying Colonial Judge's Room. He requested and secured its removal. Let me turn to the changes in the role of the High Court and in the nature of its work in his time. At the time of his appointment to that court, most civil appeals to the court were as of right. Leave or special leave wasn't required, and they were sometimes from a single judge of a Supreme Court. Those appeals were usually heard by 3 judges. Judges sitting alone still heard a number of matters in the court's original jurisdiction. During his period on the court, the range of appeals as of right was reduced in stages until in 1984 the requirement of special leave became general. The transfers of jurisdiction consequent on the establishment of the Federal Court effectively removed the single justice cases. The restriction on and ultimate abolition of appeals to the Privy Council and the extension of the requirement for special leave to appeal changed the role of the High Court significantly. It became, in the fullest sense, the final court for Australia, and it could select the appeals that it heard. And in the constitutional area, things also had changed. To recapture the political atmosphere prevailing in the early 1970s is a little difficult after the passage of more than 40 years. But to put it shortly, the relative positions of the Commonwealth and the states seemed rather different. The states seemed more influential than they now are, and to have more independence from and less dependence on the Commonwealth government, including, of course, particularly access to money. The range of activities engaged in or regulated by the states was greater, and in practical terms, they seemed to affect people's lives rather more. The phrase states' rights was much used as a political slogan, but it seemed to convey, to some extent at least, a notion that there were spheres of activity into which, as a matter of propriety in a federal system, perhaps also as a matter of constitutional law, the Commonwealth shouldn't enter. That conception was supported to a degree by the political circumstances. The Liberal Country Party coalition under Sir Robert Menzies, Mr Holt, Mr Gorton and Mr McMahon had been in government since 1949. Whilst there had been some major Commonwealth legislation in former state areas, such as the Matrimonial Causes Act 1959, promoted by Sir Garfield Barwick when Attorney-General, and whilst Mr Gorton's government had flexed the Commonwealth muscles to a degree, overall the situation had remained fairly static. But that all changed when the Whitlam government came into power in late 1972. That government had a quite different perception of the appropriate use of appropriate use of central political, legislative and economic power. After a generation in opposition, it had an enthusiasm to use it, and inevitably that would create tensions which would result in constitutional litigation. And constitutional litigation which had a political taint to it, not just because it was states against the Commonwealth, but also because the states principally challenging were governed by non-Labor governments. It had the consequence that a justice in the High Court who decided a matter in favour of the Commonwealth was labelled centralist, in favour or against the Commonwealth, was labelled centralist or states' righter, depending on the way in which he decided the matter. I say he, there were no female members of the High Court in those days. Justice Gaudron was the first. The extent of Commonwealth activity can be seen by looking at, for example, the double dissolution cases, Cormac and Cope, Victoria and the Commonwealth, and Western Australia against the Commonwealth. People are dusting off those old cases now. They involve the validity of legislation which halved the extent to which there could be variations in the numbers of voters between federal seats. They provided for representation for the territories in the Senate. They introduced a health insurance regime, and they established the Commonwealth Petroleum and Minerals Authority. The proposed electoral change was, as you could imagine, anathema to the Country Party. It was likely to reduce the number but increase the area of country electorates. The presence of territory senators would reduce the power of the states in the Senate, and uniformity of health administration along Commonwealth lines would be likely to have, as it did, as a casualty, Queensland's much vaunted free hospital scheme. And the powers of the Petroleum and Minerals Authority would be used, or could be used, to control practically the exploitation of natural resources in the oil or mineral-rich states. If one adds to the various laws the loss to the states of sovereignty over their offshore areas, which was effected by the Seas and Submerged Lands Act in 1973, which was held valid in New South Wales and the Commonwealth in 1975, it's clear that the position of the states appeared to be in serious and rather rapid decline. And one can also see that life on the High Court during that period was rather busy and also high profile. The fact that the Whitlam government only held office for 3 years has rather been obscured by Mr Whitlam's Olympian presence and his continued public visibility for many years thereafter. But the taste which the Commonwealth had had of the exercise of its powers was addictive, and Mr Malcolm Fraser's coalition government, which followed Whitlam's, had no hesitation in using Commonwealth powers when it chose, for example, by the use of the trade and commerce power in section 51(1) of the Constitution, to prevent mineral sand mining on Fraser Island, Murphy Oars and the Commonwealth in 1976. Nor have successive Commonwealth governments much restrained themselves. The High Court moved to its new premises in Canberra in 1980. You'll see the composition of the court then, Sir Garfield Barwick still presiding, the new, then very new screen behind the judges, and Sir Harry Gibbs as number 2. When Sir Garfield retired in 1981, he had been building that court had been rather one of his projects. Some Chief Justices seem to be a little obsessed by building sometimes. The Fraser government appointed Sir Harry as the new Chief Justice, except in Queensland. He had been acting Chief Justice on many occasions, and the appointment was well received by the legal profession and by the press. Sir Gerard Brennan became the replacement Justice. Gareth Evans, then a Labor senator and the federal opposition's spokesman on legal matters, was perhaps a touch less than generous in his praise of the appointment of the Chief Justice. You can probably read that, but it was a less than resounding endorsement. The paragraph that I don't think you see that immediately follows that is the one where he waxed lyrical about Sir Gerard Brennan, and how wonderful he would be. Now, in due course, Sir Harry was sworn in as Chief Justice. And you can see, I think, three photographs, one after the other, 3 photographs together that show the events of that time. He participated in many decisions in his 36 years as a judge, and it would be impossible to deal with them satisfactorily here. A very comprehensive discussion of them, on which I couldn't improve, may be seen in Glenn Williams' paper in Queensland Judges on the High Court, to which I referred. What may be said is that he believed in development of the law and in change when necessary by judicial decision, but he did not regard courts, including the High Court, as necessarily a vehicle for major social change. It is unlikely, I think, that he would have decided the Mabo cases the same way as their majorities. He would have regarded so significant an alteration as a matter for the legislature. And one aspect of his views could be seen in his observations in the second Territorial Senators case, when he had to deal with the question of overruling previous decisions. And he said no justice is entitled to ignore the decisions and reasoning of his predecessors and to arrive at his own judgment as though the pages of the law reports were blank, or as though the authority of the decision didn't survive beyond the rising of the court. He elaborated upon that rather, but that was the effect of what he said. Now, of course, there are views one way and the other about whether that's the appropriate course, and hardly surprisingly, results in that regard can tend to be tempered rather by the nature of the matter being heard. As Chief Justice, he presided with dignity and with fairness and efficiency. A particular problem he had was the strain imposed on the court by the Murphy affair, particularly when Justice Murphy insisted on remaining on the bench when inquiries into the allegations against him were still pending. During his time as Chief Justice, he represented the High Court overseas on a number of occasions, in China, at Law Asia in Manila, in India, and in Malaysia. After retirement, he remained very involved in legal and in community affairs. From 1987 to 1991, he was chairman of a committee reviewing the Commonwealth's criminal laws. In 1989, he was chairman of an inquiry established by the Queensland Parliament in relation to the conduct of 2 judges. In 1990 and 91, he conducted the New South Wales an inquiry into community needs and high voltage transmission line development, a matter which will probably never be resolved. He was the Menzies Lecturer at the University of Virginia in 1987, and in the same year Chief Adjudicator in the BHP Pursuit of Excellence Awards and Chairman of the Australian Tax Research Foundation from 1990. He also served as the President of the Kiribati Court of Appeal from 1988 to 1999. This was one of Australia's initiatives to assist the Pacific countries with the rule of law. You will see, however, that it was not all work. And the other 2 members on his right, as best I recall, are Ray Reynolds, who had been on the New South Wales Court of Appeal, and Peter Connolly, who'd been a judge from here, of course. There were also in 1990 trips to Japan, and in 91 French Polynesia and Fiji. After retirement, perhaps partly as a response to what he saw as the judicial activism of the Mason Court, he himself became active and rather more vigorously than one might have expected in public discussion of constitutional law and related issues. A particular interest was the presidency since 1992 of the Samuel Griffith Society, a conservative body formed to promote the discussion of such matters. He also took an active part against the proposal for an Australian Republic in the campaigns leading to the 1999 referendum. I said to him one day when we were having lunch, I said, if you keep this up, people will say you're the first judge since birth ever to have left the High Court for politics. He took that in rather good spirit and said, oh no, he said, they won't. During his lifetime, I used to be able to mimic his voice, but I've rather lost the capacity now. During his lifetime, he received many honours. On appointment to the High Court, he'd been created KBE, as you saw. On appointment as Chief Justice, he was appointed Knight Grand Cross of the Order of St Michael and St George. And you'll see that Sir Ninian Stephen, then Governor-General, is doing the job, and on retirement, on retirement he was made a Companion of the Order of Australia, and that you'll see Sir Ninian Stephen awarding him that. He was a recipient of the Centenary Medal in 2003. He was an honorary bencher of Lincoln's Inn and had been awarded honorary doctorates in law from University of Queensland and Griffith University. And although he was in many respects a private man, he was personally very popular and was highly regarded for his companionship, good humour and erudition. That can be seen, I think, from the photograph of the dinner given him when he became Chief Justice in 1981 by his associates to that time. You will see a few familiar faces there. And for some of us, time has rather moved on. On his retirement in 1987, the entry in the Australian Law Journal concluded, in all necessary respects, he was a model Chief Justice of Australia. I would elaborate by repeating the words we used of him in the entry to the Oxford Companion to the High Court, namely that he brought to the High Court great strength of intellect, wide knowledge and experience, a swift grasp of complex issues, a strong underlying sense of fairness and justice, and outstanding clarity of expression. He died, as you know, on the 25th of June 2005. He was 88. Thank you all for listening to me tonight.
Well, it perhaps seems a little unnecessary to move a vote of thanks, given the spontaneous reaction, but it is my pleasure to thank David on your behalf for that lecture, as always eloquent, educational and entertaining, and from a man really who is best placed to give us the paper. Can I ask you once more to thank David?